said when she said, I was like, that was dope. And she was like, something on the court. Yeah, I was like half asleep, and when she said it, I was like,
good morning, good afternoon. I never know what time of day it is. It's very bad. It is. It's 5 o'clock. Anyone see the show last year, the Jimmy Buffett show when it came to Houston, the Broadway show, Margaritaville? One. They basically made a Broadway show out of Jimmy Buffett songs. It was pretty good. I thought it was going to be stupid. But it was actually, I mean, the music was good, but they actually built the plot entirely around Jimmy Buffett songs. Unsurprisingly, the plot is you're at a resort somewhere in the tropics. But anyway, whatever, I won't ruin it. Questions, anything in your minds? Anything on your minds? Okay, let's do a poll question. So we can figure this thing out. Transition this from last class to this class. Property. Okay, start the polling session. Okay. So your question is this: simple, true or false? The contract of sale and the deed are different. The contract of sale and the deed are different. True or false?
You almost got me. I thought you said the same.
Oh, no. Different. Okay.
trying to give us the answer from the way.
No. I just read the poem wrong.
Okay. Another 5 seconds or so. Put all of your votes in. And where am I? Who was up last time? So are you next or is he next?
No, you finished it.
Oh, okay. So, Joe, are you next? No, which way am I going? No.
That way.
What?
You're going that way.
Stacy, are you next?
Yes.
Yeah, because Joe, you almost threw your entire section under the bus. All right. Stacy, what do you think the answer is? You think it's true? Okay. Tell me why.
So the contract of sales, what you showed us a couple classes ago, it's the thing full of a bunch of promises and stuff. Whereas the deed is owning the property to a person.
Well, hold on. Let's accept that. What's the difference, Casey, between a title and a deed?
So a deed is a piece of paper that conveys the title.
The instrument, right?
Yes. And
what's a title?
It's just a piece of paper.
No.
Wait, no.
The deed is the instrument, the piece of paper,
Yes.
right? What's the title?
So, when someone having title to land,
Define it without using it.
oh, curses.
How do we define a title? They gave you a very specific definition last week. Very specific definition.
It's a legal relationship between the person and the property?
Very good. Does a title refer to any instrument or paper or anything like
No.
that? Okay, very good. So, the deed is just the instrument that conveys the title, right? The title is a legal relationship, and the deed is the instrument that does it, right? In fact, if you remember last year, remember the twiddling, right, with delivery season? The expression, do the deed, that's where it comes from. The deed is actually what you did. You did the deed, right? It's related. You actually, the act of completing the transfer of property. Okay, so, Casey, back to you. So is this true or false?
That's true.
Okay, Christiana? What? You agree with it, very good. Glad you agree. What's a contract of sale, Christiana? What's a contract of sale? That's our stuff for today. The new stuff. What's the contract of sale? How do we define it? Let me ask the question differently, right? Which document is longer? A deed or a contract of sale? Let me put it like that. Which one's longer?
Contract of sale.
Contract of sale is a lot longer, right? So remember last week, right? We had the contract of sale. It was 15 or 20 pages long in your book. They had all the promises about the fixtures and the utilities, right? And if there's lead paint and disclosures. It was a very long document. The deed is a lot shorter. In fact, in your casebook, it fits in basically a page, right? So the answer is true, right? I think most of you probably got this one right. 90. Okay, very good. 91%. Okay. The deed is a fairly short document, and the contract of sale is a fairly long document. Our discussion now for the first part of class is why are these two documents different? Okay. When you're purchasing property, as someone recently did, you have a lot of documents you have to sign. The most important is the contract of sale. That spells out the specific terms of what you're transferring, what promises you're making, how you're handling utilities, how you're handling homeowners' fees. Every conceivable aspect should go on there. Is the house haunted, right? All of these disclosures. Is there a leaky roof? Is there a cracked foundation? All these things need to go on the contract of sale. Okay? But that's only one document that you're required to sign. The far more legally relevant document is actually the deed. Why? Because as Stacy said a minute ago, the deed is what conveys your title. The deed is the instrument that conveys Blackacre from person A to person B. Let me put this even more carefully. The deed becomes the public record. When you want to record the purchase of your property, that is, you want to put everyone on notice that you bought it, you're not going to record the contract of sale. You can, but it's not really necessary. The document you have to record is the deed. So this contains all of the critical information that you need to put the world on notice about what the situation is.
So the contract doesn't have to. Oh, sorry.
Yeah.
So the contract doesn't have to be recorded.
You don't have to. I don't think I did. I mean, it's not. Again, the contracts are like 30 or 40 pages, and there's lots of extraneous information. And there might be information there you don't want to make public, right? There might be some specific aspects of the transaction that you're financing, right? Which bank you're using. Oh, by the way, if you ever buy a house, you get so much junk mail because all these scammers try to contact you. Oh, we saw your record. You need to fill out this form, and you need to fill out this form and this insurance. It's all scam. It's all scam. And they make it a bigger scam because they basically put on their letterhead that they're your mortgage broker. They say, oh, we're writing on behalf of lender so-and-so, and they're not. So it's such a scam. But anyway, so to Jenica's question, you don't want to disclose more information than you actually need to. So the one-pager, right, this simple deed is about all you need. But even then, man, they send you so much scam mail. It's just toss in the trash. Don't even look at it, right? So the purpose of the deed is to provide notice to people. And it conveys several important elements. Who is the grantor? Who is the grantee? Description of the property. It's got to have the signatures and what's called the notary, or the attestation, that a person who's a notary public authorizes the person who signed it is in fact whose signature is there. Now, I discussed this last year, the difference between grantor and grantee. Elaine, did you remember? Grantor and grantee, what's the difference? Remember?
Yes.
Okay, good. What's the difference?
I think grantee is me.
Yeah, look at that. Summer break didn't wipe it out. Good. Yeah. So the grantee, right, me is the person receiving the property. The grantor is the one giving the property. So you have to know the grantor and the grantee. All right. So let me walk through the general warranty deed in your book. It's on page 595, 596. Let me walk through this with you. And then after I do the general one, I'll show you the Texas one. Okay? So this is a general warranty deed, right? A general warranty deed. Hannah, what's a general warranty deed? What does that phrase general warranty mean?
Well, a general warranty deed warrants title against all defects.
Okay, what does that mean in your own words? That's a good definition from the book. What does that mean in your own words?
So it basically protects the
Well, for whose benefit is the warranty for? Is the warranty for the benefit of the seller or the buyer? Hannah, have you ever bought a car? But you're familiar with the idea of buying a car, right? And if you buy a brand new car, right from the dealership with 0 miles on it, what will the seller usually give you to make you at ease that you're buying this brand new car? Good, a warranty, right? And I mean, whether you bought a car or not, I don't really care. But generally, when you buy a brand new car, what kind of warranty do you get? I mean, yeah, like a 60,000 mile warranty. It's also called bumper to bumper, right? If anything the car breaks in 60,000 miles, they'll deal with it. Right now, Hannah, why do you think the dealer is willing to give such a valuable warranty to someone buying a brand new car? Well, but more generally, would the dealer give such a strong warranty for a garbage car? No, okay, right. So when you're selling a good car, a brand new car, you're confident in giving what's called a bumper-to-bumper warranty because you don't expect things to break in the first 60,000 miles, right? I'm sure they do math on this. Any defect maybe arising 80,000 miles, but the first 50, 60,000 miles are probably fine, okay? This works two ways. The seller knows he's selling a good product, so he can stand behind it. And the buyer knows, okay, he's putting this warranty behind it, that means I can rely on it, okay? Think of the general warranty deed, right, as your bumper-to-bumper warranty, right? Think of your general warranty deed as like your bumper-to-bumper warranty, okay? That any defects in the title that may pop up, the seller will defend you against. So if someone comes along and says, aha, I am the true owner of Blackacre, you say, okay, I have my general warranty deed. Seller, you stand up and defend for me. And if it turns out that this guy's correct, he's actually the true owner, you pay me for Blackacre that I just lost. Right? But a bumper-to-bumper warranty is not cheap, right? You are actually paying for it. When you buy a brand new car, you say, oh, we'll give you the warranty for free. It's not actually free, right? It's baked into the price. So Anthony, what do you think having a general warranty deed for a property does to the sales price?
I think it protects against any.
No, to the sales price.
So, I would say that it solidifies the.
Does it make it more or less expensive to get a general warranty deed?
I think it would make it more expensive.
Why?
Because you're basically covering it, the whole property completely.
Okay, very good. Right. So with a general warranty deed, the price is generally higher. I think it says somewhere in the book it might be double, in some cases, what might otherwise cost. Why? Because the seller is taking a risk. He's saying, look, I'm giving you this very valuable warranty that if someone shows up and has a superior claim, I'm going to defend you. But he realizes by doing so, you say, give me more money now. So you're basically buying your safety of mind. You're buying your peace of mind by getting this more, robust, thorough, comprehensive warranty. Okay? So again, the general warranty is your bumper to bumper, everything's covered. It covers against any possible defects in title. Okay, everyone with me. Now, James, have you bought a car before? Okay. Have you bought a car that wasn't brand new and maybe was a little bit old and had some miles on it? Kicked the tires of it? What kind of warranty do those cars usually come with? The ones that you get on the dealership lot, the used dealerships that aren't the best kind of car.
Not much at all.
Yeah, but there's like a specific sticker on the window you usually see. What does that say? That's what it said? Laura, say it louder?
As is.
Very good. Yeah, as is. Thank you. Who has bought an as is car? Yeah, I have also. James, when you buy an as is car, what are you getting there? Yeah, exactly, right? Duh. Thank you. Easiest answer of the year, right? When you buy a vehicle, as is, you're taking it as it is. Whatever's there, that's what you're getting. If the engine doesn't work, if the air conditioner doesn't work, that's it. I mean, I once bought a car in the winter. This genius didn't really think to check the AC, and then came around summer, it sucked. It was in New York, not as bad here. Here I think it would work very well. But you know, you're buying the car as is. Okay? Now, why would anyone buy a car as is? It's cheaper. Right? This is not a mystery. Anyone who bought a used car, you know, you're buying a used car because you probably don't want to spend money on a brand new car off the lot with 0 miles on it. So the upshot of the as is, it's cheaper. The drawback is you might be screwed, right? If the thing doesn't work, there's no warranty at all. Okay? Think of there are 3 types of deeds, by the way. I'm going through them one at a time out of order. I'll come back to 2 in a minute. But think of the 3rd type of deed known as a quitclaim deed. The quitclaim deed, as is. Right? When you buy a piece of property with a quitclaim deed, it's as is. There are no warranties of any kind, whatever. The seller makes no promises, no representations, nothing. He's like, here, I am giving you this property as is, and if you have any problems with it, that's your problem, not mine. I'm out of the picture, right? Once the quitclaim deed is conveyed, the seller disappears. He is no longer have any role in that transaction. So Andrews, why on earth would someone take a property, or let me ask you this way, why would someone buy a piece of property given a quitclaim deed? Why on earth would someone do that?
I mean, I guess if you're a real estate developer, you don't care. You want to buy it cheap and you can probably flip it around for some money.
Ah, okay, so Andrew said, you're a developer, you don't really care about the status of the house, don't care if it's all broken down, right, because you flip it around. But Andres, we're not talking here about the physical condition of the land. We're talking about the state of the legal title. So, I mean, of course you can just demolish a house and put up, a brand new house in the lot, but why would someone buy a piece of property with a quitclaim deed knowing that someone else might have a superior claim to it? That's the better question.
I'm not sure.
It's a different question, right? It's not just a matter of demolishing the dilapidated house, flipping it, and putting it in a tax. Someone might come and say, I own Blackacre, right? Randy, why would someone do this? Why would someone buy a quitclaim deed property? Yeah, exactly. Not just physical. I mean, physical condition might be part of it, but why would someone take this risk? Well, let me ask you, Brandy, does the fact that someone gave you a quitclaim deed mean that someone else has some better interest over it? So how would you know? So a little bit louder so everyone can hear the other side. So you do your own title search, what you're saying, right? Okay, so Brandy's right. Say someone's selling a quitclaim deed and is like, listen, I don't have time to verify this. I just want to get rid of this property. I don't care. You do your own title search. And if you do your own title search, you might find that, in fact, the person selling it has the superior title to it. And the person selling it is the true owner. Then, what's the drawback? You get on the cheap, right? Now, Brandy's the honest person. Right? She says, let me do a title search. I'm going to try and be honest. Mary, what's the more cynical approach? Why would someone buy a piece of property given a quitclaim deed? Just be a little bit more cynical. Brandy's being very honest, right? Be a little more cynical.
Well, I mean, if it's cheap, then I'm just going to gamble and see if anything comes up.
And you really care if someone else has another claim to it? No, that thing's more likely explanation, right? The land is so damn cheap, you don't really care if someone else comes along with a superior claim. You just, all right, whatever, not my problem. Just walk away. Now, the bigger problem comes here, Rochelle. Right? So I'll use the 3 weeks. You're sitting right in a row, right? Brandy gives Mary a quitclaim deed, right? Mary doesn't really care. Mary flips it to you and gives it to you with a general warranty deed. What happens? And Casey comes along and says, aha, the Blackacre's mine. What happens then?
Well, if I have the general warranty, I can sue her.
You sue Mary. Right. So that's why it's important, right? If Mary takes in a quitclaim and then turns around and sells to Rochelle with a general warranty, Rochelle goes to Mary and is like, aha, You gave me a general warranty deed, defend me against Casey. And let me, Rochelle, I'm going to flip up a little bit, right? Brandy gets married, the general warranty deed, right? Good. But then she gives you a quick claim. What happens then? You're screwed. Yeah, you can't go after Brandy for the general warranty deed. You're generally going to rely on like privity, remember in contracts? You're going to rely on the person that sold it to you. And if you go general warranty deed to quick claim, it breaks the chain. Now, if all three of you had general warranty deeds, you go all the way back up the line, which is fine. But if the person you bought it from is giving you a quick claim, you're in trouble. Okay? So understand that when you buy a piece of property, anything less than a quick claim, anything less than general warranty deed, you're taking a risk. And it's not like you buy a car and the AC is broken, okay, whatever, you can fix an air conditioner. When you buy a piece of property and there's a defect in the title, you may not have the land at all, right? Someone may show up and say, aha, Blackacre's mine, and the court says, yeah, Blackacre belongs to Joey, right? And at that point, whatever, I told them before. And at that point, you're screwed. So, again, I don't know why someone would buy a quick claim unless they're a speculator. I think Andrews is right. If you're just speculating on land and don't really care. Another advantage of quick claim is it's fast, right? You don't have to go through a title search. You don't have to go through all these formalities. You can do it quick. And maybe, someone needs the cash quickly and just doesn't really care the details. But there's some risks here. So that's, yeah, perfect.
So for a quick claim, let's say someone bought it to use the mineral rights, like there's oil on the land. Buy a quick claim, drill for oil, take the oil, and then afterwards someone with superior funding says, hey, that's my land. What happens to that oil?
So there are two issues, right? One, what happens if oil may be drilled in the future, right? But the first one is, what about the oil that's already been extracted?
Yeah, that. Do they have a claim to the oil?
They could probably
sue for royalties.
Yeah, I think they could probably sue for royalties for past drilling. I think we'd be able to, especially if, just think of it this way, right? If the land was already owned by, say, me, and you were drilling on my land, you're basically committing a trespass. And one of the remedies in case of trespass for drilling is that you can recover lost profits. In other words, had you been the one on there, those would have been your profits.
Okay.
Yeah, I mean, think of it no different than like an adverse possession case, right? Where Mr. Robinson was squatting that guy's house, right? I don't know, let's just say he found oil in the backyard. Then Bank of America come along and say, that's my oil, right? So I think you get royalties. Actually, one second. I was going to show it later, but I'll bring it now because you mentioned oil. I have a warranty deed from Texas. Someone wants to bring it up. Where is it? Here. I'll show this to you right now. I found this. It's basically a template, but it's a warranty deed. By the way, warranty and general warranty are the same thing. So if you ever see in the real world just a warranty deed, that's been the same thing as a general warranty. The phrases are used, interchangeably. So this is a warranty deed. It says, State of Texas, County of fill in the blank. No old men buy these presents. What you'll find in this language is a lot of very old phrases that don't really make sense, but some lawyer 300 years ago has put it in, and the court said you need that phrase, and now lawyers are afraid of removing stuff, because if we remove this phrase, maybe it's not valid. So you basically have all these old phrases that build one on top of the other, make no sense, and lawyers are afraid to delete them because they might be necessary. So no old men buy these presents. It's like, hey everyone, we're announcing it to the world. If you care, the Articles of Confederation has a very similar style at the beginning. Not that you care, but it's a very similar phrasing. Okay, that I, fill in the blank, county whatever, say whatever, for sum of $10, offer good and valuable consideration to undersign, the grantee, acknowledge that grant is all conveyed, county whatever, okay. This is what I probably want to show you. This was a conveyance of property subject to the reservation of oil, gas, and mineral exceptions that are contained therein. So this is a case where you can actually convey the surface rights, but not convey the subsurface rights, which might be oil, gas, minerals, whatever happens below the ground. So what you'll often have a case is, to use Brooks' example, where property is conveyed and the deed only speaks about transferring the surface rights. It's silent on the oil stuff, right? And then lo and behold, you find oil that actually is not yours. The royalty belongs to whoever down the road had the original title on fee simple, surface and subsurface. So if you are purchasing land, especially I think in Texas, make sure you understand that you probably don't have the surface rights. I actually checked, 'cause I'm a nerd, but I did not get the surface rights to my townhouse. You know, it's just surface, not subsurface. So I don't have any oil rights if I drill in my little concrete backyard. If it's a car, basically. But to your question, Brooke, specifically, if there are minerals and you didn't obtain the subsurface rights, then it goes up the chain, whoever had the original surface rights. And it might be someone who's been dead 100 years, and you gotta find like their great-great-grandson. And that gets very complicated. Because people don't think, right? So this is a general warranty that mentions the subsurface rights. I got another one, I think this is from, this one's from Brazoria County, Texas. It doesn't mention oil rights. So it basically just assumes you're transferring, but if it's an assumption, it's only the surface rights. So this actually becomes a huge issue if oil is found, for example. Any questions on that? Very good. So we've done two. We've done the general warranty deed, or the warranty deed. Again, the phrase general, you'll see it sometimes, you won't see it other times, so don't depend on it. You have a quitclaim deed. And by the way, quitclaim is both a noun and a verb. It's used in a very odd fashion. Say, I quitclaim the property to her. You'll hear that sometimes, right? I quitclaim the property to him. That means you gave him a quitclaim deed. I don't know why they say that, but it's, you know, you quitclaimed it. Whatever, you'll see. Okay. The second type of deed is what's called a special warranty deed. Brooke, oh, you're next. Perfect. Brooke, you want to tell us what's a special warranty deed?
Special warranty deed contains warranties only for the grantors.
Very good.
Not previous owners.
Very good. Right. So the special warranty deed is like the middle of the road. Okay? It warranties only against the acts of the grantor. That is the immediate person who sold it to you, right? The person you bought it from. It doesn't guard you against acts from others, right? So let's say, again, I'll use my Brandy, Mary, Rochelle, right? If Mary gives Rochelle a general warranty deed, Mary is only liable for any errors that are her fault. If there's some mistake that Brandy made years earlier, it's not relevant, right? So if Mary put a mortgage on the property and didn't disclose that to Rochelle, Mary will be on the hook. But if Brandy had a mortgage on the property and never told anyone, Rochelle can't go back. So again, Brandy gives Mary general warranty, Mary gives Rochelle special warranty, the chain's broken. You can't go back up to Brandy. So it basically cuts off the chain, right? The chain only goes back to the person you sold it from. You can't go after any errors or defects that are resulting further down the line. Perfectly through the sitting next to each other, just works perfectly today. Okay. All right, so any questions on these three? Again, so the general warranty is like your bumper to bumper, your full warranty. The special one is like a limited warranty. Think of like, any defects that the that the dealer gave, and quitclaim is no promises, no warranties, nada at all. Okay, so any question on those three items? Those three types of deeds. Be very careful on the exam and otherwise that you pay attention to what kind of deed I'm giving you. Because if I'm only giving you a quitclaim deed, then there's really nothing the buyer can do. I'm giving you a special warranty deed. Take careful notice of what is being done by whom, right? If it's an error by the seller or an error by a seller many years earlier, some might be covered. And if it's a general warranty deed, that gives you the chain, and you go all the way back up the chain, back to the original seller. Okay. Any questions on that? Oh, yes, sir.
So for the general warranty deed, it goes all the way back to the person who first gave that warranty though, right?
It goes as far back as the general warranty deed, right? So imagine like, Andres gives Brandy a quitclaim deed, right? Rochelle can't go to Andres.
Right.
But she can go back to Brandy because you have general warranty, general warranty, general warranty, you build the chain up. Because really what happens, think of like CIFPR, right? Remember they did impleading, right, for civil procedure? Basically what happens is Rochelle sues Mary, and then Mary sues Brandy. And that gets all three of them in the same action. But it's not actually that Rochelle sues Brandy, it's you have intervening actions. Because, think about it. Rochelle sues Mary, and Mary's like, I don't know about it, it's not my problem, go after Brandy. And that's how you all three into the action. But it's got three different lawsuits, really, to think about it. Or 1, 2, 3. Okay. Everyone with me so far? All right. Go back to your book, The General Warranty Deed. I want to actually read through this. Okay. Again, the contract of sale is a very long document. We did that last week, and it has 15 or 20 pages long. Lots of personal information. You may not want that to be recorded for public records, especially if there's certain promises you made that are not public. You may not want to make them. Might be financial information you don't want to know. Okay, so let's go through this. It says, I, John Doe, grant to Nancy Rowe, and her heirs and assigns forever. That's an important point. Josh, what's the significance of that phrase, heirs and assigns forever? What does that phrase mean? Probably so it's contracts, I think. Maybe not. Well, what does heirs and assigns forever mean? What's an assigns? You know what that word means? What does it mean to assign something? Okay, right? So what assign means is, okay, Nancy Rowe has it today, but Nancy might convey it to someone else. This is Brandy, Mary, Rochelle, right? Brandy gave Mary the general warranty deed, but also she's guaranteeing her assigns forever. That if Mary gives it to Rochelle, or if maybe Rochelle inherits it from Mary, Brandy's on the hook. That's what that language is doing. It's creating the chain. It's saying, I'm not only giving you the general warranty deed, I'm giving everyone in your chain, in your lineage, the same warranty. Right? You can break that by giving a quitclaim. Don't forget that. If you give a quitclaim, you break the chain. But by giving this language, Brandy's saying, I am opening up to everyone that may ever come into this contact with this property with you, I'm giving you this guarantee. Right? So I granted Nancy Rowe and her assigns forever for $10, real cheap, and good and valuable consideration, just like contracts, right? Consideration, the peppercorn, whatever it is. The following real estate situated in the county of wherever, described as follows. And then it says, insert description of land. Now, Matt, how do we describe what land someone's buying? Okay, but that describes the size of it, right?
You're talking about quality of land.
No, it says insert description of land, right? What would be important to insert there? If you're buying Blackacre, right, what's the most important thing you want to know about Blackacre for public record? Well, today we have addresses, right? You live on 1303 San Jacinto Street, right? But before there were addresses, what would you want to know? Where it is, the location, right? You don't think about this way, right? You say, oh yeah, I live at 1303 San Jacinto Street. The idea of an address is a fairly novel innovation, right? That's only the last 200 years, whatever it happens to be. What was very important for describing a deed is the location. Where is it located? And again, there's no GPS, right? You can't say latitude 25, longitude, whatever, right? Instead, the common law developed a specific system of measuring the boundaries of property. A very specific system for measuring the boundaries of property, and it was called meets and bounds. Meets like meters, like measure, and bounds like boundaries. Okay? This was a way of describing where a property is. But it wasn't very precise, because it might say Blackacre extends from 25 feet from the river to 15 feet from the mountain, 5 feet from this tree, and 4 feet from that barn, right? Why is that problematic, Austin? Why is that a very, tricky way of defining property?
Because reference points to destroy, disappear, move.
Exactly. Reference point to the habit of moving and disappearing. For example, water, right? What might happen if, say, 25 feet from the river? What might happen?
River can shift.
River can shift, exactly. The tree might get cut down. The barn might burn. So a lot of disputes that have arisen are precisely because the boundaries aren't clearly defined. Now, the more property you have, you can create what's called a survey. And I'm not going to show you my house survey because it's this funny document, it's hard to read, but it's basically a blueprint of where you are. So it says, 15 feet from this street, 5 feet from this street, 2 feet from the house on either side, and it describes it. And so long as those other things are present, you can probably figure out where your property is. Of course, if your house is in the middle of nowhere, it's hard to always do precisely. There's no GPS in deeds. They don't have that sort of precision for location. I guess you could, but it's not really done. So the description is very important. And a lot of disputes over adverse possession we've studied are because they didn't have the survey right. Remember that case in Washington where everyone's house was 50 feet over from where it's supposed to be, and where they had the staircase that went a couple inches over to the property? These are meets and bound problems, and they still exist. Okay, so just insert description of land. Okay, this next phrase, to have and to hold. To have and hold. When there's a footnote, it means it's important, right? Like, read, what does that mean, to have and to hold? What the heck does that, what's the significance of that language?
That you can do what you want with it.
What does that mean, to have and to hold?
It may function to limit the estate.
Yeah, okay, I'll read it for you. It's whenever you see a footnote in the middle of a sentence, you know it's important, right? This is one of those old feudal phrases. It's called, and you might, I swear, I had a student who emailed me, and she said, this came up in her practice. I didn't believe it, but this came up. She was the only one in her firm who knew what this was. A habendum clause. Where is it? I can't read it. Habendum. Just highlight it, put it in your memory bank. You'll never see it ever again, maybe. But I had one student said, I had this thing, and no one else knew what it was, and I remember from your class, so here, take it. A habendum clause, right? Right? It means to have. Like, was it habemos papam? What's the phrase in the Pope? We have a Pope, right? Habemos papam. When the smoke comes up, the Pope tweets habemos papam, right? No. No, we don't do that? Not yet. Maybe we have to do that soon enough. Okay. Oh, there it is. Anyway, so this is a very important phrase. This is a very important phrase that every deed will have. The language is necessary, but it means that you have this property to hold, it's yours, and that there's going to be no doubts about it. Anyway, so I only mention it because it came up once with a student and never again. Okay, so it says to have and to hold the premises, the privileges and appurtenances belonging thereunto. Again, this language is gobbledygook. These means you have certain rights to the property, that's all it means. To the use and the grantee, and her heirs and assigns forever. That's the important point. This is a general warranty deed, not just for you, but anyone you sell it to. If you put this quitclaim deed, you don't have that language. If you put it in a special warranty deed, you're not going to have that language, right? It's going to be a limited warranty. But the general warranty has, again, the forever part is very important because that's what creates the chain from Rochelle up to Brandy. That's how you get the chain. Everyone with me? Okay, the next paragraph is very important, and there's 6 separate elements. And they're numbered here, which makes your life easier. But there's 6 separate elements. They're called covenants. Covenants. Jake, what is a covenant?
Like something assigned to you, basically.
Just what does the phrase covenant mean?
An agreement.
Promise. Yeah, very good. A covenant, think of it as like a promise. Right? A promise to do something or not do something on land. The deed has 6 covenants. The deed has 6 covenants. Okay, let me read them to you. It says, the grantor for himself and his heirs and assigned covenants. That means he promises. Number 1, the grantor is lawfully seized in fee simple of the premise. Caitlin, this phrase seized, what does that remind you of from last semester? I can drag you back before summer break. Seized, what does that phrase remind you of? Well, the fox, yeah, capture. But there's another, more precise, seize, that word. We use that phrase in different contexts. Think of the twiggle. Esther? Very good, Esther. What's livery season?
The whole bundle of sticks.
Yeah. Yeah. Livery season, remember when they put the clump of the dirt in the hand? It's unfair to ask you remember more than 3 weeks ago. Okay? I'll limit myself to whatever we did this semester. Livery season means you own the property, and that was done for the conveyance of the clump of the dirt. Right? That was the conveyance of the clump of the dirt. So when they say the grantor is lawfully seized in fee simple, what does that mean? The grantor is fee simple, right? Again, is lawfully seized, it adds nothing to the sentence. It doesn't change the meaning one word. The important word there is fee simple. You remember what fee simple means? You have the full bundle of sticks. Okay? Right, but told, why is that important to say that the seller has fee simple? What by the seller saying he has fee simple, what is that conveying to the buyer? Louder.
He has full title.
What does full title mean? Let me ask you, if you're the buyer, right, why do you want to know that the seller has fee simple?
So that you know, like, the chain of
Okay, very good.
where it goes.
Very good. The reason why the first one's important, because you're the buyer, if your seller has fee simple, then you get fee simple. If your seller has a full bundle of sticks, he's giving you that full bundle of sticks, and now you have it in fee simple yourself. It's a very important conception, right? So the first covenant, I'll number them for you. The first covenant we have is called the covenant of season. You might spell season. You're going to see it spelled different ways, but it's the same thing. The covenant of season, right? That the seller, the grantor, has title to the property they're selling you. They have a full bundle of sticks. They have fee simple. Okay, one thing. Let's go on to number 2. Number 2. That the grantor covenants that he has a good right to convey the fee simple. Okay, idea, why is this one important? That the grantor covenants that he has a good right to convey the fee simple. Very good. Let me ask you a question though. If you have fee simple, should there be any doubt about whether you can convey it?
You might not know.
Ooh, but if you don't know it, do you have fee simple?
I'm sorry.
If you don't own it, do you have fee simple?
No.
So then what does the second guarantee add? If the first guarantee says you have fee simple, it means you have the full bundle of sticks. Is the second one even necessary? But you're exactly, my question is different, right? Is there ever going to be a case where you have fee simple but you can't transfer it? But if you have fee simple, can there be a limit on your ability to transfer? If you're in a will, you're dead, right?
Okay.
But if you have fee simple, is there ever going to be a case where you can't transfer it?
No.
Like we did a case last year, remember, where someone said, leave the property to my daughter or my niece, but you can't sell it. Remember that? I can't remember the name of the case, right? Did she have fee simple in that case, idea? Said you can live in the house for the rest of your life, but you can't sell it. Yeah, right? Life estate, exactly. So, what I'm trying to convey, and she's playing a good foil to me, which I appreciate, is the second one's largely redundant. It's repetitive. If you have fee simple, then you have the full bundle of sticks. And for the full bundle of sticks, you can sell it. There's not a doubt. But lawyers like to be safe. Better safe than sorry. So they repeat the same thing over and over again. First one says you have fee simple. The second one says you also have fee simple. it's the same thing, just phrased a little differently. Because to say you have fee simple means you have the right to convey, you have the full bundle of sticks.
If you have like a life estate, then you can't have a warranty.
Then you don't have fee simple. You can't give a general warranty with a life estate. Right, Marcel's question is good, right? If you have a life estate, you need to give something less than that, maybe a warranty deed, maybe a quick claim. But if you don't have a fee simple, you can't give a cover season. Because by definition, right, someone else will get it when you die. Right, the very nature of a life estate means when you die, there's a remainder man floating around who will take Blackacre from you. So you can't give a warrant. I mean, you'd be fraud if you tried. I guess you could, right? Imagine you have a life estate, say, aha, I have fee simple, you committed fraud. Okay. So the second one was called the covenant of the right to convey. Right? There might be some very strange case where a person who has fee simple but can't convey it, but it's going to be a very bizarre case. I mean, generally speaking, it's the same thing, but lawyers like to be safe. I mean, there might be a weird case you can think of, but it doesn't matter. Of course, it doesn't matter. Okay. Let's go next, number 3. It says, the grantor covenants for himself and his heirs assignees that the premises are free from all encumbrances. Roxy, what's an encumbrance?
Like mortgages or liens.
What if like a tree fell on the property and like it blocks the front door? Is that an encumbrance for what we're talking about here? You know, there's an earthquake and a tree fell down and blocked the front driveway. Is that I mean, it's encumbering access to the property. Is that an encumbrance for our purposes here? You're right. She's right. I'm trying to trick her, but she didn't fall for it. Yeah. Encumbrance refers to legal defects. A mortgage, an easement, a covenant, etc. Now, here's an important point. Edwin, what if there is, an easement on the house? For example, the place I bought, I have a 10-foot easement along the back which allows cars and stuff to pass through, right? My property. Can I not have a general warranty deed if there's an easement across my property? But what has to happen? Bingo, gotta disclose it. So you can have an encumbrance on your property. So this language is probably not ideal. You would need like a subject, however, to all easements we list here, 1, 2, 3. So you can still get a general warranty deed if you acknowledge that there's an easement on this property. For example, like cars pass through. Okay? So number 3 is what's called the covenant against, I never spelled this right. Good, I got it. The covenant against encumbrances. It's a tongue twister. The covenant against encumbrances. Okay? Now I want to focus on something, right? Pay attention to the tense, right? You have present tense, you have future tense. In numbers 1, 2, and 3, everything is in the present tense. The grantor is lawfully seized. He has a good right to convey. The property is free from encumbrances. Each of the first 3 are known as present covenants, right? Present covenants. They're called present covenants because they can only be violated at the time of the transaction. They're called present covenants because they can only be violated at the time of the transaction. Think of it this way. First, either the seller has fee simple or he doesn't, right? There's no debate about that. Second, he can either convey it or he can't convey it. There's no doubt. Either it's yes or no question. And then third, there's either a mortgage on it or there's not. There's an encumbrance or there's not. There's no debate, there's no doubt. Okay? Why is this important? Because the present covenant can only be violated at the time of the transaction. Therefore, there's a statute of limitations. Right? If you want to sue for a violation of one of the present covenants, for example, you didn't really have fee simple, you didn't have the right to convey, there's encumbrance, you have to do it within X years of the sale of the property. I think it's about 5 years usually, but whatever it happens to be. Right, I'll give you the example of your statute of limitations, don't worry about the year. But you have to know that with the present covenant, you have a clock, your statute of limitations. If you wait too long, you're SOL. I'll never forget it. Statute of limitation. Right? But even if you don't remember what I just told you, you pay attention to the tense. You are lawfully seized. You're in it now. You have no encumbrances. It's all set in the present tense. Okay, come with me. In contrast, look at 4, 5, and 6. Will forever, right? Will guarantee. Will means future. So the first 3 are known as your present covenants. Okay. The next 3 are known as your future covenants. I'll do these in turn. But you have to keep them separate. The first 3, and they might not always be listed in the same order. I can trick you on that. It's easy enough to do. But when you see present tense, you know that they're present covenants. And when you see future tense, you know that they're future covenants. Right? Any questions so far? So let's go through them one at a time. So number 4 says that the grantor and his heirs and assigns will forever warrant and defend the grantee and her heirs and assigns against every person lawfully claiming the premise or any part thereof. So there are 2 parts to this, right? The grantor and his heirs, which means I'll just go back to Brandy. Brandy says, I promise, and if something happens to me, my heirs will defend you. And if Brandy sells it, the person I sell to will defend you, right? This is a perpetual guarantee, right? It goes on as long as there's a chain in existence. So it says that the grantor and his heirs and assigns will forever warrant and defend. Who? Mary, the grantee and her heirs. So even if both Brandy and Mary, God forbid, are not here anymore, their heirs can duke it out in court, right? That's one of the difficult concepts of covenants we'll be covering this semester. Even after the initial buyer and seller are not with us anymore, their heirs and assigns can then fight as if they were the original buyers and sellers. That's the power of the general warranty deed. People step into their shoes and can fight as they would. So specifically, the grantor and his heirs and assigns will forever warrant and defend the grantee and heirs and assigns against every person lawfully claiming the premise or any part thereof. That means, in the future, if anyone shows up and says, aha, I own Blackacre, Mary can sue Brandy, or Mary's daughter can sue Brandy's daughter, or whoever happens to go, right? They can have that connection. Okay? Critically, though, the present covenants, you start writing the statute of limitation when? At the time of the transaction. But, Lucas, thank you. Lucas, when do you start writing the statute of limitation for future covenants? When do you think?
Whenever the breach happens.
When the breach happens, exactly right. So if 30 years after Blackacre sold, someone shows up and says, aha, Blackacre's mine, that's when you start running the statute of limitation clock. Not from the transaction date, but when the breach occurs. Someone shows up and says, aha, I have a claim to it. Okay. Some questions on that? Yeah.
Is that starting from the start of the transaction or when it's completed?
You start running the clock when someone shows up and says, aha, I have Blackacre.
On the first one. Sorry.
Oh, you're asking about the present covenants?
Yeah.
Probably when you sign and when the deed's signed.
When everything's done.
Yeah.
All the papers are signed.
Yeah, I don't know if it's when recording, but I think it's when you sign the deed itself. Okay, so let me go through each four one at a time. So the first one, and these are all very repetitive. 4, 5, and 6 are basically the same thing. There's not much of a difference. The first one's called the Covenant of General Warranty. And that takes its name from the title of the deed. It's a general warranty deed. Well, that means that the seller will guard against any lawful claims, and if there's a loss, Brandy pays Mary for Blackacre, whatever the value is. Very helping. Yeah, okay? Good? Oh, the charger fell. It's okay. All right. Everyone with me on the first one. Okay, let's read number 5. Number 5 says, okay, we're all friends here, that the grantor and his heirs and assigns will guarantee the quiet enjoyment of the premises to the grantee and her heirs and assigns. Justin, what's this phrase, quiet enjoyment mean?
That their possession of the property will be encroached on.
Does that mean like they won't be allowed music? What's this quiet enjoyment?
I mean, I guess that like once the conveyance is through, there's not going to be any like kind of reneging on it or anything like that.
Okay, yeah, very good. 4 and 5, I mean, are basically the same thing. There's not a lot of difference, but it basically means you'll have quiet enjoyment, that no one will come along and assert a superior claim. Right? You have quiet enjoyment, no one will try and disturb your possession. It has nothing to do with like, no loud music, right? It's not a nuisance stuff. It's no one comes along and bothers you. 4 and 5, if there's a difference, it's beyond what you need to learn in this class. It's basically the same thing. I'm sure there's a difference, but you don't need to know it. It's not that important. Okay. The last one's actually is important. The grantor and his heirs and assigns will, on demand of the grantee or heirs or assigns, execute any instrument necessary for the further assurance of the titles of the premise that may be reasonably required. Samantha, what's the 6th one? Why is that important? Why is number 6 important?
Because the grantor is basically telling them that if they need anything further to protect the title, they are
Good.
going to.
What might they need? Just guess. I mean, it's not your reading, but what might they need to do?
Verify that they're talking about the same property.
I mean, just imagine, right? Brandy and Mary in a transaction, right? And then years later, Mary says, "Uh-oh, I need you to do something." What might pop up?
Defend them against the claim.
Yeah, related. All right, anyone want to take a guess? Take a guess? Yeah.
Provide proof of
Yeah, provide documentation for stuff. Right? If there's any doubt about who owns it, there might be like some, photographs of living there, right? Maybe there's like, a tax bill to show that they were on the property given time. The 6th one is actually fairly common in contracts. It means that you will take steps to help the person perfect their property. That you will ensure that they've actually, that everything's settled. Remember first the production of documents, right? That you're not going to be, in other words, you're not going to be a jerk, right? That if there's like, a tax bill from 30 years ago that might prove that there's no adverse possession, you give them the damn tax bill, right? You assist them in whatever they need. And if you notice, it's phrased demand. Well, on demand. It's not, can I ask pretty please? Would you please? It's demand, and then you do it. So you're assuring them that if you need my help, I will take care of it. And this last one is called the Covenant of Further Assurances. Sounds a lot more complicated than it is. But it basically means we'll give you documents if you need it. And again, 1, 2, and 3 are all present covenants. They breach the time of the sale, if at all. And then number 4, 5, and 6 are the future covenants that can be breached really any time in the future, so long as you have the chain connected. All right, so any questions on these 1, 2, 3, 4, 5, 6? Okay, so let me ask you one more question, right? What do I have to? Marcel? Let me ask this question, please. So last week we did a case where with a haunted house, right? And the buyer sued, right? What did he try to do in the haunted house case? What was his actual remedy? Do you remember what he tried to do?
Didn't want the house.
He did not want the house. What did he ask the court to do?
To resign the contract.
I'm sorry, what word?
To resign the contract.
Rescind the contract. Yeah, rescind the sales contract. The cases we did last week were about rescinding the sales contract, right? They were suing on the contract because the contract said that there are no material defects in the property, whatever it says, right? And it was haunted, right? But you can sue on the contract, or you can sue for breach of the deed. They're often going to be very similar, right? And let me make this point very bluntly. And this is actually what Andrew and Brooke were asking me last week, or last class. The covenant against encumbrances, in almost all cases, will overlap with the issue of marketable title. I said again. The covenant against encumbrances will almost in all cases overlap with whether your title is marketable. So if you have a marketable title, then in almost every case, this covenant's going to be fine. If you have a violation of the covenant against encumbrances, then you probably don't have a marketable title. Okay? But in such cases, you can actually buy the land, and if you later discover that this title is breached, you can then move to rescind the sales contract, or sue for breach of the covenant against encumbrances. So you generally have two options, right? Again, the Lohmeyer case was a contract case, and the one we have later today, the Connecticut one, Frimberger, is based on the deed. But they're very similar. The court uses language that goes back and forth about marketability. The concepts are fluid. So I didn't want to kill you on that last week. But as a general matter, this covenant against encumbrances is very similar to the issue of marketable title. Everyone with me? Okay. Now, why does this matter? You might have different statutes of limitations, right? So maybe the statute of limitation on the contract is 2 years, but the statute of limitation on the present covenant is 5 years. So if you burn your statute on the suing on the contract, you might still be able to sue on the deed. So why does it make a difference? Depending on the given facts of your case, you might have a different option. It's also possible that you have a quit claim deed. If you have a quit claim deed, you can't sue on this covenant, in which case you'd have to sue on the contract. So whether you sue on the contract or the deed is going to be very fact specific. But the inquiries are almost identical. And if you see courts talk about encumbrances, marketability, marketable, they use the language in a very, much my dismay, a fluid way. They go back and forth in a way that sometimes confuses me and everyone else for that matter. But they don't always precisely say which one they're suing on. Because you can imagine, right? You just bought a house. You're going to say, I'm suing on the contract and the deed. You sue on both. And the court might not even distinguish between the two of them because they're both at issue. Maybe you can only sue on one, maybe you can sue on the other. But generally, if you're a smart lawyer, you sue on both because it gives you more chance of prevailing. You either try to rescind the contract or find that the present covenants are breached. Everyone get that much? Good? Okay, very good. Okay, let's see what we got next. All right. One note, forgery. A forged deed is void. Right? That is, if someone signs my name and they're not me, it's a void deed. I was complaining, but I shouldn't have, when I was doing the closing, that the title company demanded photo ID, and she demanded that I sign my name the same way every time. Like, why did she do this? I know the answer. Because if someone walks in and says they're Josh Blackman and they start signing my name, the deed's not valid. Right? You can't sign for someone else. You have to be very precise in how you sign the paperwork. Okay? Any questions on that? All right, let's go on to the, one more, the indenture. I love this point. Everyone's heard the phrase indentured servant, right? But no one knows where that phrase came from. Back in the day, there were no copy machines, right? When you had a deed, you take this big piece of sheepskin paper, write the deed on the top, and then write the deed on the bottom. And then you would cut it in a very specific jagged fashion. Why you're doing this? You'd separate them. Give one to the grantor, and give one to the grantee. What happens? If there's ever a dispute about the authenticity, like Captain Planet, you put them back together, and see if they fit, and if they fit, that's a match. That's a match, and you have the authentic document. Yes, Liz.
On page 598, it means the difference between forgery and fraud. Could you further explain?
Well, a forgery is if someone signs my signature, right? Fraud is where you induce someone to sign at a false pretense. You say, for example, I'm selling you Blackacre, and indeed what you're selling them is Whiteacre, right? So forged deeds are fraud. Forged deeds are void. Fraud is a little bit more tricky because it goes on other things, but as an easier matter, forgeries are not valid, right? Which is why signatures are so important. By the way, do you know credit cards are going to get rid of the signature slips? Visa, MasterCard, Amex, starting next year, you no longer need to sign for credit card slips. You know why you have to sign? I just make a squiggle. But there was a time when they would actually check the signature on the paper, the one on the back of your card, to see for forgery. Now, no one cares. I just squiggle. Yeah.
Can you have an agent sign for you and it not be a forgery?
You'd have to establish what's called a power of attorney. What that means is you basically designate an agent attorney to sign for you. You can have a limited power of attorney or a durable, which basically lasts forever. I would be very hesitant to do one of these because you're basically giving someone the power to take on lines of credit for you and acquire property. It's very risky. So sign your own damn papers. It makes your life easier. It means your hand will hurt, but you're at least doing it yourself. Any questions on this? All right, let's look at the first case. Who am I up to? Kendall? All right, Kendall, you want to give me the facts, please, in Frimberger versus Anzalotti.
Yeah, so the defendant's brother and his son had the property. He transferred the property to the defendant by quitclaim deed.
Okay. What kind of, where was the property located, just as a general matter?
In Old Saybrook.
Yeah, I know, but where was it near? Like, what was the geography or the climate of that area?
The wetlands.
Yeah. So, what's a wetland? Well, these people are swamps, but wetlands is much nicer, so they're called wetlands. If you're buying property near wetlands, don't. These are environmentally very difficult places to build and to live. What does it mean to fill in wetland? Well, when you have this sort of swampy, this very moist soil, you can't build on it, right? You have this land, but you can't really build because it will sink in. So what used to be done is that you would fill this swampy land. You would take cement, you would take rocks, you would take garbage, whatever it happens to be, you'd fill it. Little known fact, Manhattan, right? Lower Manhattan didn't exist 300 years ago. It's basically filled in earth. They just basically expanded the size of the island. I think Ellis Island also was in the same boat, right? There was a time when you needed to build, you just fill in the soil on sort of swampy land, also the District of Columbia. You can't do that today. There are state and federal laws that make it virtually impossible to build on a wetland. You have to get permission, you have to have what are called environmental impact statements. There's very strict rules, and I think there's something in notes about it. Read on if you like. So what happened here, and I think Kendall's explaining, is you had a piece of property, and then someone filled in part of the wetland to basically build on top of it. They didn't get permission, they didn't get authorization, but they built on top of it. Okay, so Khadijah, what happens next?
So, when they were trying to build on it, they were notified.
Yeah. Well, before they, how are they notified, right? Just walk through the process of what happened to get to that notification, please.
From the point where he tried to build the property.
Right. So he filled the property. What happened next?
Oh, then he hired engineers.
Well, but there were some transactions first, right? There's some intermediary transactions.
It was conveyed by Warranties. That was all encumbrances, the subject to building.
Very good, very good. Okay, so the brother of Anzalotti filled some of the land on the wetlands. Okay? At that point, the property was transferred to the defendant by quitclaim deed. No assurance in the quitclaim deed. No assurance at all. Okay. Then, about a year later, the defendant conveyed it to the plaintiffs, Frimberger, by a warranty deed. Now, Lance, as a general matter, you're buying something with a warranty deed. What do you look for if you're buying it from someone with a warranty deed? What are you going to probably want to check on?
Any defects?
Well, just think of, oh, she's not here, but the Brandy, Mary, Rochelle line, right? If Mary is selling to Rochelle with the general warranty deed, what's Rochelle going to want to find out?
She's authorized.
Not just authorized, but what else might be a useful piece of information for her to find out? Again, this person has only been in the land for about a year. What might they want to know? Alec?
Encumbrances?
No, I'm not sure. You know what I'm looking for? Anyone? Yeah?
How, like the warranty that was conveyed to the...
Yeah, you want to figure out the chain. Your guy, the guy selling it to you, the grantor, has been there for 1 year. All right? You want to know, how did this person acquire it? And you can find that, right? The reason why deeds are recorded is to create that chain. So figure out who has what. So, Brandy, we called you. You're out, but I'll call back a minute ago, right? If Brandy gives Brandy gives Mary a quitclaim deed, and then Mary gives Rochelle a general warranty deed, Rochelle's going to be nervous, right? Because she can only sue Mary. She can't go after the original Brandy. You want to understand my point, right? So if you're buying something with a general warranty deed, and you figure out that a quitclaim deed is earlier on the title, you're limited to the most recent seller. Just Mary, no one else. Everyone get that much, right? Okay, so the general warranty deed says, free and clear of all encumbrances, but subject to building and zoning restrictions. Right? But subject to building and zoning restrictions. Katie, what's the significance of that language? We've done a little bit like that before. Why is that language significant?
Because it's, I guess it's the covenant against encumbrances.
Right, there's a covenant against encumbrances. What does that mean? Free and clear of all encumbrances, but subject to building and zoning restrictions. What does that mean?
That, like there may be building and zoning restrictions, but...
What does it mean subject to? That's what I want you, what does it mean subject to? In other words, you're in Connecticut, right? Is there any land that's not subject to zoning restrictions? No, I mean except for the city of Houston, right? Every jurisdiction in the United States has zoning law. I mean, everywhere. So, Katie, subject to. What does that mean, subject? Does that mean violating, or just those laws apply?
I guess if there are any, whichever ones there are.
Okay. So this is why I think a lot of ambiguity arises. If I say subject to all the restrictions, that just tells me, yeah, there's zoning laws in this city. You know, the existence of a zoning law doesn't render the covenant violated. Right? The mere existence doesn't render it violated. Okay. So then what happens? The property is transferred, right? The property is transferred, and then what happens? The new guy comes in. And then he makes the fatal mistake. He tries to play by the rules. Right? He tries to play by the rules, his mistake. He calls an engineering firm and says, here, can you guys figure out what the deal is of this land? No. Shouldn't he have done that before he bought the property? Yes. He should have done it before he bought the property, but he didn't. So he comes in, he brings in a firm, the firm says, uh-oh, not so good. They call the government, they say you need to do a survey. They conduct a survey, and the government writes a letter, and they say, hey, you have some filled wetlands. You can't do this. You're violating the statute. Harrison, at that point, did the state take any action against him with that letter? They said they violated the law?
I mean, it's kind of like a right to cure, right?
I'm sorry?
It's kind of like a right to cure.
Yeah, you can cure it. How could he have cured it, in theory at least?
I mean, kind of state why it's necessary for him to have that fish.
Very good, very good. Right. He could have submitted an application to the government and said, here's why it's necessary to have this filled land. Harrison, do you think that application would have been granted? Oh, you're much more nice than I am. No, I think it's a waste of time. He would hit with massive fines, and he probably have to remove the bulkhead. I mean, I guess maybe it's possible he can show a hardship, but he'd been living there for 2 years. You know, it seems like vacation, whatever, home, whatever it is, by the water, he would be screwed. Now, here's a key point. Celeste, did he actually apply for that application? Did he actually try and explain why he had a necessity defense?
No, he did not.
What did he do instead? He sued who?
The person who bought the last one.
Exactly. Now, just I'll use Rochelle and Mary because they're sitting there conveniently. Rochelle sues Mary. Is Brandy in this picture, the guy who filled the land? Why not?
Because the deed was under.
What kind of deed was initially conveyed from Brandy?
Not the second one, the specific one, wasn't it?
Yeah.
That was the quick.
Yes, ma'am. Yeah. So what happened was, first was a quick claim, and the second one was general warranty. You can only sue one layer back. The chain only goes between those two. It doesn't go any further back. Understand? Okay, so Celeste is correct. They went ahead and sued. Now, there's a fairly common element in law called exhausting your remedies. Exhausting your remedies. What does that mean? Before you sue, you have to go through various hoops, administrative remedies. You have to apply for a license that's going to be denied. Why do you waste your time applying for a license that's going to be denied? Because if you don't, this is what happens to you. The court says, aha, he didn't apply for his license, therefore he loses. So, again, always apply for pointless licenses and just wait for your denial, and then you sue, right? You sue after you get denied your license. Don't just go ahead and do otherwise. This happens all the time in law, and people who don't follow these steps often are out of luck. An example, not that you care for constitutional law, but there's a case called District of Columbia versus Heller, which involved the right to keep and bear arms. And a number of D.C. residents sued, saying, aha, I need a gun. One of them, a guy named Dick Keller, went to the government, City Hall, and says, I want a gun license. They said, what are you, an idiot? We don't give gun licenses. I want one anyway. Denied. He sued based on his denial. He was the only one who had standing. The other ones who just had an abstract desire for a license were tossed out of court. But he asked for a license he couldn't get. He won the Supreme Court. So, just a lesson for you to learn. Okay. Anyway, so, goes to the court. So, Megan, is the violation of these land statutes, does that constitute an encumbrance in violation of the covenant?
This court said no.
It does not. Why? How can that be?
Their reasoning was that it didn't affect the marketability of the title.
Oh, okay. So now my Brooke and Andrew, a question from last time, right? Where does marketability come from? What does the concept of marketability refer to? Where did we raise that one last class?
Title?
Yeah, the contract of sale. The analysis here, again, I sometimes I assign this case, sometimes I don't, because I always get angry at it and I go back and forth. It's a good case, I think it explains the facts, but it uses terminology in a way that I think is somewhat confusing. Marketability refers to the title, right? The title refers to the contract of sale. But this case is about the deed, and what should be talked about as a covenant against encumbrances. But the court uses it interchangeably, right? Which is why this case, I think, is in tension with the Lohmeyer case from Kansas, the last class, right? And there's actually a note, the very first note after this case, like, is this consistent with Lohmeyer? And the answer is no, not really. So let me just explain this to you very carefully. Lohmeyer last week said, right, this was a case about if you have a violation of a zoning law or a violation of a deed, that could render the title unmarketable. But here they say the violation of this environmental law isn't enough to render it unmarketable. Again, the Kansas case said violating a zoning law renders it unmarketable. This case says violation of the environmental law is not enough to render it unmarketable. What this case is actually getting at is that having a violation of our environmental law is not enough to trigger the covenant against encumbrances. But they use the word marketability and encumbrances in a way that is somewhat, I think, a little confusing, and it's not this court's fault. This is a common way of looking at it. They're very much an overlap. So the mere fact that the covenant against encumbrances is affected
right? Because you have this this environmental violation, and my God, you're on the hook for damages, right? The prospect of litigation, you're getting sued from the government on this one. You're getting hit with fines. That's not enough to violate the covenant. Why? Because the government hasn't sued yet. This is the part that always gets me upset about this case. Everything else I can live with. They say basically, until the government takes enforcement action against you, the covenant has not been triggered. Right? If the government takes action against you, then you're screwed. But again, by the time the government sues you, you're going to be facing these massive fines. Let me tell you guys, the way these fines work, it's every day. Right? It's every day that you're in violation, it's $100 a day, whatever happens to be. These fines can ruin you immediately. You can't deal with this. So the court's holding here, I think, is good for environmental law, right? Because imagine the alternate holding. Every single contract, or sorry, every single deed that has some sort of environmental issue becomes voided. Law of land is voided. So this is a pro, I think, environmental decision that allows environmental law to operate without rendering titles void. But the second the government comes after you, oh boy, you're going to have a lot of damages to pay. All right, so let me just summarize this case again. The existence of violations, right, what's called a latent violation, the existence of violation is not enough to violate the encumbrance. Okay. And again, just keep this just in your mind when we come back to the case involving the Kansas case from last week, because I mean they're not in tension, but there's some overlap there. Okay. So questions then on the Connecticut case. Okay. Okay. So you're gonna be happy and sad. Don't worry about the next case. I'm not going to test you on it. They changed the case book, and I decided to assign it, and I regret assigning it, so just forget it. Let me explain the reason why I'm telling you to forget it. It discusses covenants running with the land, which I'll cover in about 3 weeks, but you haven't done it yet. So if you suffer for that case, it'll help you for 3 weeks, but this one I'm not going to test you on. It's a bad case, the Iowa case. Whenever they come up with a new book, I say, oh, maybe I'll try this case, and it doesn't work. All right, so let me summarize, and I'll let you out of here in a minute. Make sure you distinguish between the contract of sale and the deed. With a contract of sale, the question is the title marketable? Right, that's what we focused on last class. But with the deed, you have to think of each of the 6 covenants. You're going to have 3 covenants that are in the present tense, covenants of season, the right to convey, and then against encumbrances. And those all say the same thing. Is the person selling it actually the true owner, and other defects? Those have to be brought at the time of sale, plus a limitation period of 5 years, whatever it is. The next 3 are the future covenants. These covenants can be brought at any point in the future if someone comes along and says, aha, I'm the true owner, and then you can go back to the original seller. But so long as you have a chain of general warranty deeds, go all the way to the chain. But if you have a quick claim deed in the path, it severs the chain. Okay. Questions on this? No? I'll see you guys on Wednesday. Thank you so much.